Hello, today I'm going to present a successful defensive asylum case that we prepared for an immigration attorney. Here at Immigration Paralegal Services, we've been writing for many immigration attorneys, and I know that you guys have been dealing with a lot lately. Trial queues, quick turnarounds, and there's constant changes to law and policy. I also know you want me to cut to the chase and tell you why this service is important. The crux of it is this: attention to detail. We take the time and make sure everything is covered and discussed because these cases can come down to the smallest details. And that's really what wins cases. At the outset, I want to let you guys know we are an experienced immigration paralegal service. We provide a broad range of contract legal support services to immigration attorneys nationwide. We are not a staffing paralegal firm or a law firm. Now, what I'm going to do is I'm going to go over one of our many success stories. Recently, we were hired by an attorney to draft a defensive asylum brief for the immigration court in Chicago. I present to you the case of Mr. Antonio Banderas. Obviously, that's not the name, but we value the privacy of all our clients, so this is just a placeholder name. But today we'll talk about why this succeeded and asylum was ultimately granted. First, we begin, like many of you, with a statement. Us writers go over the statement in detail. We highlight every important detail, no matter how minor. Let's take a quick look at the statement that we prepared for Mr. Banderas. As you can see, we start with a little biographical information. We talk about background because in many cases that helps set up the PSG if a PSG is needed. We talk about the events at hand. Here, Mr. Banderas was a truck driver who met some resistance by FARC dissidents. It's not the easiest case. I'm sure many of you have dealt with cases that involve guerrillas or gangs. They're not easy, and many judges just say, this is just a truck driver. He was caught in the middle of some criminal activity. Personal, financial, whatever, doesn't meet asylum. But we don't leave it at that. We demonstrate each interaction with his persecutors. Each threat, we show the escalation. We highlight the important information, such as, in this case, let's say, they were monitoring me because they needed to assist their revolutionary cause. We use words like that. Make sure to highlight things like, I believe it says war materials in here somewhere. Yes, war materials. Those are big buzzwords that we can use to help sell this case to a judge. We also mentioned, like I said, minor details. He received phone calls even after he changed. He declined requests to involve himself. We mentioned everything because taken together, they form the basis of the case. And while not featured directly here, many times we go over the country conditions in great detail, usually hundreds of pages. Yes, we have the Department of State Human Rights Report there. However, we have other rights reports, Human Rights Watch, Insight Crime, studies, articles, everything, and we refer to that in various phases of the brief. So now we get to the argument. We reviewed the statement, we've reviewed everything. Now, what's left is the argument itself. So here are our PSGs, Colombian truckers who refuse to cooperate with FARC, Colombians who refuse to cooperate in illegal activities with FARC dissidents, and immediate family members of XXX. Okay? Obviously, the name's not there. So, we take our time to articulate a valid PSG. We make sure that our proposed PSG is supported by case law with similar or sometimes identical wording from either the board, circuit courts, anything that demonstrates cognizability. Okay, over the years, we've seen many proposed invalid PSGs at the immigration court level, and then an attorney comes to us. They want to do an appeal, and it's hard to present new arguments. So even at the earliest stage, we like to bring in as many PSGs as possible because sometimes it will come down to, let's say later, they say there's not a persecution. We want to make sure that the stage is set for an appeal if need be. But obviously with the FARC component, we will be adding the political as well. FARC, has their connections with the government. So once again, we use every detail to talk about FARC, mutable characteristics. We tailor the PSG to the best of our ability with the case law that's provided. Okay, so like say for example here, we mention Escobar v. Holder. Now Escobar v. Holder demonstrates that this PSG is cognizable. It stated that a trucker cannot cease being this characteristic and delineated that Escobar's past action and resistance to FARC are immutable characteristics. He was also a truck driver, so obviously that's something we mention. That's something we highlight. And then we start talking about continue with particularity and social visibility and how he's seen within society. We never want to give the immigration judge or an appellate judge something to hang their hat on specifically. Okay, next we talk about family. We cover that in detail. We want to make sure that every avenue is covered. As you can see, we once again utilize LexisNexis, make sure that law is up to date. I want to be clear here at this stage right now. We do not use AI. Regardless of how familiar you are with it, it has its problems, okay? And we don't want you or anyone else getting dinged. We make sure that the case law is up to date and it's correct. So here, in this particular area, we argue the familial relationship between Antonio Banderas and his son. As noted, FARC wanted to recruit his son as well. That was in our statement of facts. We highlight the case of Hernandez Avalos v. Lynch. It's the same here. Antonio stopped FARC from recruiting his son, and that's why they wanted to kill him. We highlight this PSG. Again, these are the precedents we cited for the IJ, so they can recognize our client's proposed PSG based on kinship ties. Family. And next, we didn't forget about the political opinion. Okay, once again, we talk about the issue, we define it, we provide the solution, and go over every facet of political opinion. We give them as much case law as possible to back that up. We don't want to give the judge any reason to think otherwise. In addition, we use the country conditions yet again to strengthen our argument. Say, for example, here, we talk about the country conditions give a clear picture of FARC, how the government has issues with them. There's human rights challenges. One of the most difficult challenges are those facing FARC dissidents. And then we start talking about all the issues that are prevalent throughout the entire country. And this continues throughout. Okay? So in this scenario, the Second Circuit, in this case, has also recognized resisting corruption, abuse of power, including non-governmental abuse of power, can be an expression of political opinion. Okay? So for example, Del Pilar Delgado v. Mukasey, Second Circuit, 2020, the court ruled that a refusal to give technical assistance to Colombian FARC could be an expression of political opinion. In that case, the respondent testified that FARC targeted her because of her knowledge of her computers, a reason unrelated to political opinion, but the court emphasized in that case that the petitioner later testified that FARC soldiers threatened to kill her if she did not collaborate with them. Now, taking that into account, court said it did not necessarily follow that because petitioner's original kidnapping had not been politically motivated, her refusal to provide further assistance did not support a well-founded fear of future persecution on account of imputed political opinion. Thus, the court remanded that case. Now that sounds very similar to what we just described in our statement of facts. Okay, Antonio Banderas was asked to join FARC, subsequent flight from them to the United States, and they imputed a anti-dissident political opinion to him. His resistance and refusal to comply can be seen by FARC dissidents as a defiance against their authority. This resistance can be interpreted as a political stance against corruption and illegal activities conducted by FARC. The dissidents likely perceived Antonio Banderas and his family as threats to their control and status in Colombian society. Thus, they have imputed a political opinion to him. We follow this up with nexus. Once again, every avenue we want to make sure is taken care of. That way, if one falls short in some judge's opinion, there's plenty to back it up in case it goes back to remand. They can't say, even if this wasn't the case, this was the case. No, we want to make sure that doesn't happen. I'm sure you've had many issues where they say, oh, well, this is a valid PSG, but what's the nexus? Where's the persecution? Or vice versa. We make sure that that does not come out of the judge's mouth, if we can help it. So here we talk about, the nexus requirement that you guys are familiar with. Here there was plenty of things that demonstrate that he was persecuted on because of this, the threats, all of those things established nexus. There should be no issue there, and obviously there wasn't because this one was approved. Finally, persecution. Once again, we cover past persecution, we cover future persecution. This is important, once again. That way, if something comes back, they say, you may have shown past, but don't worry, that situation's gone for the future. Say there's a political party change, anything like that. We make sure past and future are covered. That way they can't, once again, as we say, hang their hat on something else. So we make sure we cover past persecution here, and later we get into future persecution on what else might have occurred in the future, or say, for example, we refer to the country conditions. Since then, FARC has garnered even more power. They're even more dangerous. That also strengthens the case overall. And obviously this is important. We have all that case law. We have the country conditions. There is no control over FARC. All of those things we've discussed demonstrate that. So we build this rock-solid foundation with all the facts available. We do this in every case. As we said, if one case gets denied, at least the attorney representing the respondent, they have a grounds for a successful BIA or Circuit Court appeal. Time and time again, if they are not well presented at lower courts, very limited in what you can do. We want to give you as many tools as possible to deal with that, to see that, to make sure that if you don't win at first glance, at least there's a possibility for appeal. Our process saves you guys time. It gives clients the best possible chance at winning. We know time is valuable, especially nowadays. Cases they used to run, 3-4 years on average? Family cases, they still are somewhat beholden to 6 months. We've seen that speed up, and what the service provides is a means to let you continue doing what you can for your clients in the best possible way. Okay? The attorney representing this client has informed us that the case was granted, and we couldn't be happier for the client, for the lawyer, because their success is our success. Okay? Thank you for your time.